Guess what? You guys made it to the final chapter, chapter 14, Collateral Proceedings and Writs. Basically, real quickly, let me say that collateral proceedings, they actually refer to those proceedings that are not part of the normal judicial process involved in the conviction and sentencing or acquittal of a defendant, but they are a necessary part of the criminal justice system. First, we're going to look at extradition. The extradition proceedings may be international or interstate. Interstate extradition is referred to by some legal writers as rendition. So first we're going to look at interstate extradition. It is based on an article within the United States Constitution which provides a person charged in any state with treason, felony, or other crime who shall flee from injustice and be found in another state shall on demand of the executive authority of the state from which he fled be delivered up to be removed to the state having jurisdiction of the crime. Most states have actually adopted the Uniform Criminal Extradition Act. Prior to this act, it was necessary to prove that an accused had actually fled from the state in which the crime was committed to avoid prosecution. The adoption of the act permits extradition from any state, even though the accused did not voluntarily go to that state. This can occur from either a misdemeanor or a felony charge, but due to the expensive nature of this process, it is usually only done on felony cases. Requirements for extradition. There must be a warrant of arrest outstanding for the individual. The prosecuting attorney of the county in which the crime was committed will make an application to the governor of his or her state. The application is a request for the governor to make a demand on the governor of the state where the accused is presently located, demanding their return. The application must show the name of the fugitive, the crime, the approximate time and date, the circumstances surrounding the crime, the state and location where it is believed the fugitive is located. The state in which the fugitive is located is referred to as the asylum state. Acting on the extradition request. The receiving governor will review the application and determine if they should surrender the fugitive. They may request the Attorney General or any prosecuting attorney to conduct an investigation into the matter. If the governor in the asylum state is satisfied with the demand, they will issue a governor's warrant. After the fugitive is arrested, they are taken before a local magistrate. The magistrate will set an extradition hearing date and may even grant bail. Two major facts are considered in the hearing. Is the fugitive in custody the person named in the accusatory pleading of the demanding state? And was the fugitive in the demanding state at the time the crime was committed? If the magistrate is satisfied, the fugitive will be turned over to the custody of an officer of the demanding state and returned to that state. So what if the fugitive is already arrested? Frequently, the fugitive has already been arrested on another charge. Most states permit a temporary detention of the arrested person until extradition proceedings can be instituted. Sometimes the proceedings are waived. This waiver will eliminate the application to the governor, and the arrested person is taken before a local magistrate from whom consent to be returned to the demanding state will be given. And as far as refusal to extradite, there have been times when a governor refuses to honor the demand for extradition. The United States Supreme Court and many state courts have held that the governor of an asylum state has a duty to abide by the demand, but there is no authority that can compel the governor to do so. It is held that the governor of the asylum state must either abide by the demand or refuse to extradite. Next, we're going to look at federal law against unlawful flight. Congress passed the Unlawful Flight to Avoid Prosecution Act, or statute, which permits the federal government through the FBI to assist in locating and arresting badly wanted fugitives. In most instances, the local prosecuting attorney must agree to handle the extradition proceedings. International extradition. It is based entirely on treaties with certain countries, which specifically identify the crimes in which an accused may be extradited. In most cases, political crimes are excluded. These situations are handled through the Department of State. And our very last slide is writs. A writ is defined as a mandatory precept under seal issued by a court. and commanding the person to whom it is addressed to do or not do some act. A writ of habeas corpus maintains a purpose to obtain the prompt release of one who is being unlawfully detained. The right to this writ is embodied in the United States Constitution and in laws of all states, and states that every person unlawfully imprisoned or restrained of liberty under any pretense whatever may request a writ of habeas corpus to inquire into the cause of the imprisonment or restraint. And finally, a writ of certiorari is issued by an appellate court to permit the review of a decision or judgment by a lower court. It is often used when other means of appeal are not possible. It is granted by the state Supreme Court to review a lower court's decision in order to establish guidelines to be followed in future cases by either trial judges or lower appellate courts. The writ is automatically issued in most jurisdictions to review a case when the death penalty is imposed. Generally, the United States Supreme Court only accepts about 2% of the writs that are filed with the court. And that wraps up the book. Thank you guys so much for your patience and your academic efforts, and I hope you got a lot out of each one of my lectures, and I hope you guys have a great end of your semester and good luck on your final exam.